Faculty View at Case Western Reserve School of Law. My name is Ameera Haider, and I'm a 2016 graduate of the school, as well as an ABA Moot Court competitor. Today I am here with Professor Andrew Pollis, who teaches in the Civil Litigation Clinic, as well as coaches the Case Western Moot Court teams. Professor Pollis has recently written an article called Trying the Trial, which focuses on changing the litigation conduct within the courtroom. Professor Pollis' article was recently published in the George Washington Law Review Journal. So, Professor Pollis, could you please give us an overview of your article?
Sure. Thanks, Ameera. Well, kind of by way of background, I practiced in civil litigation for 18 years before I came to Case and started teaching. And here at Case, of course, as a supervisor in the clinic, I'm still doing litigation. And it's always distressed me throughout my career the way you see some of our adversaries behave. Conduct that is not cordial, that is unprofessional, sometimes unethical, and they succeed in behaving this way. There's no real disincentive. In fact, it's quite the opposite. Some of our most prominent lawyers and our most successful lawyers are our worst abusers of the litigation system. So it seemed to me that we need a strong way, a kind of robust way of making sure people don't have an incentive to misbehave when they are engaging in civil litigation, lawyers in particular.
Right.
And the way that I've come up with is to allow evidence of that misconduct to make its way into a trial and to let juries hear and evaluate that evidence and to bear on their decisions as they reach their verdicts.
So could you please explain a little bit more what this bad conduct exactly is?
Sure. In my article, I break it down into three different categories. The first category is changing positions to suit the moment or backpedaling from positions previously taken. And let me give you two illustrations of that will explain what I mean. One arose in the Ford rollover litigation, and for those who don't know, the rollover is a Ford SUV that had a design defect, allegedly, that caused it to roll over on impact and create severe injuries for the passengers. And in one of the very first trials that Ford defended in California, the jury found a design defect, and then the case went into a punitive damages phase where the jury had to decide whether to award punitive damages. And at that point, Ford's lawyer made a strategic decision. And what he did was he apologized to the jury for the design defect and basically said, we're really sorry that we let you down. And then in subsequent trials, Ford has successfully blocked that apology from coming into evidence. So in any other context, any other company official who acknowledged a defect, that would have been clearly admissible. But because it came from a lawyer, the courts have said no. And I think that's simply wrong. I think that you shouldn't be able to take a position where it suits your purposes in one case and then not have to live with that decision in another. Another example that's actually even more egregious is here in Ohio, two people were convicted and sentenced to death for being the trigger man in a murder when it's absolutely clear, physically impossible for both of them to have done it. Only one of them could have. But the prosecutors chose to prosecute each defendant individually and allowed each jury to believe that each was the trigger person, even though that was physically impossible. Right. And so to me, these kinds of tactics where you're really kind of taking advantage of the system and saying what suits your purpose, that's not okay. And jurors should be aware of it so that they can reach appropriate verdicts, taking that inconsistency into account.
So that's the first category you proposed. Now, what are the other two categories that you mentioned in your article?
The second category is what I call abusive litigation tactics. And this is really kind of the worst for the day-to-day lawyer, really, because it's when you're dealing with adversaries who just make your life difficult. It's one of the biggest complaints that litigators have about the profession, is how difficult their adversaries can sometimes be to work with. We like to think of the quintessential lawyer as Clarence Darrow or his fictional counterpart, Atticus Finch. But in reality, it's more like Rambo, and Rambo litigation tactics is actually kind of a term of art that you hear a lot in litigation circles. And it shouldn't be that way, but it is because it really goes unchecked. There's very little judicial supervision. There's very little you can do by way of an ethics complaint. Most of this happens outside the courtroom, for example, in depositions. That's where it happens a lot. In fact, it happens because it's lucrative, and the lawyers who engage in it, they don't pay any penalty for it. They're actually more successful. So the best example of that, to my mind, is a lawyer who recently passed away, he behaved so badly in litigation that one court, in a rare exercise of supervision over this conduct, called him out on that conduct. This lawyer had, in a deposition, called his adversary an asshole, you'll excuse my language, and said, "You could gag a maggot off a meat wagon." That's a direct quote. And that was the one case in which the court actually called him out on it. There are many other examples, including on YouTube, of his engaging in similar behavior. But in that lawyer's case, he was so successful at what he did. He bulldozed his way through litigation. He won lots of cases. People settled with him because they were afraid of him. And when he died with a $1.7 billion estate amassed through collecting on judgments. He was known as the King of Torts. And a major law school has 2 busts in his honor and a tribute video on its website, which to me sends a message to prospective law students that that's how we want you to behave. This is the behavior that we want you to model, and I just think that's wrong.
So now, what is the third category that you mentioned in the article? The
third category is withholding evidence or destroying evidence. And the term that courts use for that is spoliation. That's what it's called. And this obviously happens when people are afraid of evidence. When they don't want the fact finder to actually see what the evidence is, they will destroy documents or refuse to produce them. And courts, of all 3 categories, this is the one that courts have addressed most frequently. But unfortunately, the way courts have addressed it has kept the details of what occurred from the jury. Jurors have really not heard a whole lot about that kind of bad behavior, so it never really factors into jurors' decision-making in the way that I believe it should.
So in light of this bullying and evidence being suppressed, what are remedies that you propose in your article?
Well, it seems to me that if jurors could hear this evidence of this lawyer misconduct, it would assist them in reaching their verdicts because it has an inferential value for the results. Generally speaking, people behave in this kind of conduct to mask weaknesses in their cases. So you switch positions because you don't like your first position, you move to a second. You misbehave because you know that if you practiced with more integrity, you might have a harder time winning. You hide evidence if it's harmful to you. And I think jurors should be able to evaluate that kind of conduct for 2 reasons. One is, as I said, it's got that inferential value that could help them reach maybe more accurate verdicts. And the second is that if we permit jurors to hear that evidence, then finally we'll have a very strong disincentive to the lawyers that engage in that behavior, and maybe they won't find it lucrative. They'll actually have a reason not to behave that way, and that would inure to the benefit of all of us.
Given that we have a current existing rules of evidence, how would your proposal fit into that existing body of law?
Well, it's an interesting question. If you look closely at the evidence rules, they say early on that they are about truth and justice, or just determinations. That's the ostensible purpose of the rules. But there are several provisions in the rules that actually have a different purpose. They're not so much about truth, they're more about fostering other policies. So for example, we don't allow evidence of hearsay. That's when somebody makes a statement to a third party and then the third party comes to court and tries to report what that statement was and offer it for its truth. Even though that could have assistance in getting to the truth, we don't let it in. We don't allow jurors to hear evidence of settlement offers, even though the party that made a settlement offer, by making that offer, ostensibly recognizes potentially some fault, but we don't want to chill the settlement process. So we've made a determination that we care more about settlement than truth in that instance. And privileged communications are not admissible. So what you tell your lawyer, what you tell your clergy person, what you tell your spouse, all of those communications, which presumably, because of the intimacy of those relationships, are fantastic means of getting to the truth, we find it more important to protect the sanctity of those relationships. So it really isn't about the truth. My suggestion that the evidence of litigation misconduct be admissible has a policy objective like these other provisions, and that is the policy objective of discouraging bad conduct. But unlike those other areas where we sacrifice truth for the benefit of the policy objective, the proposal I'm making is actually more in keeping with the truth for the reasons that I said before, because of the inferential value. So it enhances the truth, and as the evidence rules recognize, it encourages or actually discourages certain kinds of bad behavior.
So are you suggesting that evidence of bad conduct should always be introduced in a trial?
No, I think there's a danger to doing that. And again, that's where the evidence rules come in and speak very nicely to the issue. Because under the evidence rules, we have balancing tests. Evidence can't be admitted unless its probative value outweighs its prejudicial value. And by prejudicial value, we normally are referring to confusion of the jury, or causing them to feel emotional about one side or the other, or maybe having an undue effect on the length of the trial. So it's a case-by-case determination, and in every case, it will be the judge's responsibility, as it already is, to weigh the probative against the prejudicial value. Right. The problem is that when it comes to attorney misconduct, judges seem categorically to exclude the evidence without really submitting that evidence to the balancing test that the evidence rules contemplate. Right. And so my suggestion is to move the kinds of conduct we're talking about away from that kind of forbidden zone into the traditional balancing test that the evidence rules contemplate. And when that happens, sometimes it won't come in if it really doesn't really belong in the trial. Right. But other times it should and it will. And that's the sum and substance of my suggestion.
Well, as Professor Pollis explained, he's proposing a very novel approach to keeping the courtroom more fair. Do you have any parting thoughts for us, Professor Pollis?
Well, I just hope that my article will gain some traction and that I'll get a judge or two to start paying attention to it.
And if you're interested in learning more about Professor Pollis's proposal, his article is available through the George Washington Law Review Journal. Thank you so much for speaking with us today.
Thank you, Ameera.
Bye-bye.